This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
Of course. Nobody said anything to me. Oh, I don't know. Nobody's asked. Sure. You ready? All right, good morning, everybody. We're here in case 2020 CF 3014, State of Florida versus Ashley Benefield. And we are here for a first that have been, I'll say, consolidated for one extended hearing time. We were originally scheduled for 15 minutes. I don't plan on holding all of that. All right, here's what I have down. I've got defense request for paralegal to remain at counsel table for trial. I've got a state motion in limine for proffer of expert testimony. I've got the 12th Circuit General Counsel's motion to quash subpoena and enter protective order. I've got scheduled down that I want to go over my pretrial colloquy today with the attorneys and the defendant so that we don't have to take time to do that on Monday. We discussed that there might be some redactions that have not been agreed to the 911 call. The issue of the defendant's proposed jury questionnaires. The defendant's motion for clarification. And a state's motion to quash.
And Judge, that motion to quash the state will be withdrawing because the defense withdrew their subpoena.
Is that correct, Mr. Taylor?
Yes.
All right. So that will be gone. All right. It doesn't really matter to me the order that we go. If you want to leave it up to me, I'll probably start with the 12th Circuit's motion to quash the subpoena for Vicki Mechanic, and that way Ms. Floyd can finish her portion of this hearing and go on.
Thank you.
If that's all right?
That's fine, Your Honor. Just to alert the court, we are going to ask to address the court for our response ex parte. We have information that runs directly to the defense that I don't care to reveal, and I would request an ex parte hearing on the record, and I would like to have Ms. Floyd present for it.
Okay. We can do that. Deputies, I know this is kind of last minute, and I had forgotten about that to kind of think ahead. What we'll probably do is when we get to that point, the court reporter, Mr. Taylor, the defendant, Ms. Floyd, and I will go back into one of our jury rooms, and we can have the hearing, the portion of the transcript be sealed into a further order of the court. So I'll need one deputy to go with me, and then the rest can stay out here.
And Your Honor, Ms. Mechanic is present today. May she come with us?
I don't know.
Mr. Taylor?
I don't know what the subject matter is going to be. I assume she could be there, but...
Because of the significance to the defense, Your Honor, I would like to restrict the discussion to only the absolutely essential part.
All right, we'll start that way, and then I'll see as we go. But you guys are in charge of security. Will that plan work?
Yeah, we'll work fine.
All right. So that's what we'll do. All right, Ms. Floyd.
Thank you, Your Honor. Your Honor, I know you've seen my motion. It's pretty similar to the one that I argued just a few weeks back regarding the subpoena on Judge Moreland. It's a little bit different, but only as to the fact that Ms. Mechanic was a judicial assistant, not a judge. And since I know you've read my motion, I'm not going to beat it up, but I do want to say that I believe, without getting into something confidential that Mr. Taylor would like to keep that way for the moment, that what he's looking for, I think he could get it other ways. I think he has other avenues to get what he's looking for, possibly through a public records request, which as of this morning has not been lodged with our public information officer. Also, I have concern that, bringing a judicial assistant in here just opens the doors to the confidential communications between judges and their assistants. And that's just not something that can be subpoenaed. I'm worried about setting a precedent, Your Honor, and we'll address the rest of it after Mr. Taylor has given you his argument.
Okay. All right, if that's it, then you want to go on camera at this point?
Yes, sir.
All right. So can you, Madam Court Reporter, I think it would be just easier to go in this first jury room. Did Deputy Racky already step out?
Oh, he just stepped out for a moment.
Okay.
Judge, in the meantime, while we're waiting, is there anyone waiting in Zoom?
I didn't start it. Nobody asked me.
Okay. I don't know if my secretary normally handles that, so I don't know if there's anybody trying to log on. So
I don't either. Are you asking me to start Zoom?
Yes, give me please.
So it's better practice just wait until he gets back? Sure, fair enough. I figured. Of course. And you guys may have suggestions about how it's better to be handled. I understand. Well, while we're waiting on that, I went over this list. Was there anything that I missed that we need to cover today? Anything additional?
So, Your Honor.
Is that everything you have on your list, Ms. O'Donnell?
Yes, Judge.
Good? Okay. Madam Court Reporter, you probably want to get set up first, I would think, because you need to get in there and plug into an outlet.
Yes, sir.
And
Ready right now?
whichever one is the bigger one, the very first jury room that we use.
Yeah, we're fine. I didn't know we're doing it right now, but we're good.
Okay.
Yes, we're good here.
All right, Mr. Taylor and Ms. Benefield.
Okay.
And Ms. Floyd, please.
Jack. I consider Mr. O'Keefe to be an essential party.
No, you can handle this.
All right. For the record, I requested him to attend the court.
The court reporter's not here. You can put it on there.
All right.
All right, State.
Yes.
It's not a huge room, so one of you needs to go.
Okay.
Just one. no, I'm sorry. No, I apologize.
I was like...
You're exactly right. Never mind. Okay. I'm so used to both parties having to be present, it throws me off. All right, we are back in the courtroom after having conducted the in-camera hearing. And I will make a note to do an order to seal. Transcript and 2 exhibits. All right. Yes, sir, Mr. Taylor?
Yes, Your Honor. Having now had an opportunity to confer with Mr. O'Keefe, who was prohibited from accompanying us in the ex parte meeting, I can represent to the court that the answer to the court's inquiry is yes. The information was included. And I would like to make certain that that response is included in the transcript for the hearing.
Pursuant to obligations under 3.220.
I'm sorry?
Pursuant to the obligations, the defendant's obligations under 3.220.
Yes,
The answer to my question is yes.
that's correct.
Okay. Having heard the argument of the defendant, argument of the attorney for the 12th Circuit, Ms. Floyd, considering the motion to quash subpoena and enter a protective order, at this point, based upon the very limited grounds upon which Ms. Mechanic may be called, and there's really no way for me to do, I will do my best to give a ruling that doesn't fly in the face of the ex parte hearing. But I will say this, the ability to call her is limited in that there are I'm going to write this one. So I'm going to stop the oral ruling at this point, and I will write what I mean to say.
Thank you very much, Your Honor.
Would the court entertain at least announcing whether or not the subpoena is quashed?
No, I want to.
All right,
I want to write through it.
We're 5 days away from trial, Your Honor.
When did you issue the subpoena, the trial subpoena? When did you issue the trial subpoena?
June 26th, Your Honor.
It's on the subpoena.
So less than 1 month before the trial, that's been pending for over 4 years, and the trial subpoena, the trial stipulation that was signed January of 2024, you issue a subpoena. We just now have the hearing on the motion to quash when it was just served. I will do my best, sir, but I'm also presented with a certain very limited window of time to address these matters through no fault of the court.
Thank you, Your Honor. May I have the excuse?
Yes, ma'am.
Thank you.
All right, how about the redactions to the 911 call?
Ms. Friel will be handling that.
All right.
I have a copy for you. Do you mind? We've been going back and forth, and I just struck through what we've agreed upon, and then what's left in yellow is what is in dispute. It's a few instances, Judge, but it's highlighted in yellow.
And I might say that we've had excellent cooperation back and forth in an effort to try to minimize what the court has to consider.
I would hope so.
Thank you. The first one would be page 1 on line, and the cover is not numbered. We ended up with weird page numbering, but we're going with it. Line 21 and 22, I'm not letting her go back in. The state feels like that is not a presence since impression. It's hearsay. He's had time to reflect and make a decision, and that it should be struck.
As court may recall, Your Honor's ruling, even though we cited present sense and 2 other instances for admissibility, the court's conclusion was that the 9/11 tape was admissible pursuant to it being a spontaneous declaration. These statements are happening as this event is unfolding. They are being stated by the speaker in response to what's happening. They could not be more of a spontaneous declaration, and we believe they are clearly admissible for that reason.
Final thoughts?
Just that the whole rule of presence and impression is based on spontaneity. So saying things that are happening as an event is happening. And this clearly shows that he had time to reflect, because he's stating, I'm not letting her go back in. It means he's thought, and now he's decided, made a decision, and I think that is not, therefore, a presence.
All right, thank you both very much.
Yes, sir.
I've already ruled that these are not excited utterances. I think my ruling was, I don't have it in front of me, that the entire call did not impress me as qualifying as excited utterance. However, the spontaneous statement of present sense impression, I felt that there were a number of things that could come in that way, and then there's certainly other statements that would not come in. This one in particular, I'm going to allow it. And here's why. It's not an excited utterance. It's not a present sense impression, but it's not because it's not describing or explaining an event while perceiving or immediately thereafter. This is a statement of then existing mental, physical, emotional condition to prove, I assume it's going to be offered, to prove action in conformance therewith at a later date. So I think it would be admissible under that provision. So that one is allowed.
We're going to, there's an overlap, and so you're going to go to page 7 next, please.
7.
Oh, I see. Okay. I see what you're doing.
Overlap, so I just struck through I just left it struck through because we hadn't done, until we were done, so we could do the redactions and there was no confusion.
All right, so just to be clear.
Yes, sir.
Well, are you putting this in?
I think so. Yes, but we were planning to not with the strike throughs, but I left them struck through so there was no confusion as to the parts that were being stricken until we were done. So we would black them out. If Your Honor wants us to modify it in some way, I'm happy to do it.
I'm not going to tell you how to perfect your record.
Yes, sir.
So to be clear, I'm looking, when I say I'm allowing a certain line, 21 and 22, I'm looking at a transcript that has page 1 on it, and at the top it has 911 call, and I'm allowing from lines 21 to 22, and I'm not letting her go back.
And just for the record, and just to make sure Your Honor understands what I did, there's 2 911 calls, as you know, they transfer it, and there was a part that overlapped. So like on page 2, I put continues on page 6, mostly for myself until we get it, and then I just put them all together and we numbered them so that it was easy to have today's hearing and for us to figure out which pages we were talking about. So the next one would be page 7, which is the second portion of the transcript, lines 2 through 4. This is the same argument from the state. He says we need the police before her mother and the little girl gets back from the park. I don't want them to find this. And the state feels that that is something he's had time to reflect on. It's not an excited utterance, and it's not a present sense impression. He's thought about the fact, he's asked her apparently before the 911 call, according to Mr. Sant, where her mother and child are. She says at the park. Based on what's going on, he's made the decision he doesn't want them to find this, and so the state feels like it should be stricken.
Mr. Taylor.
Judge White, our position remains the same. This is a spontaneous statement of the caller reacting to these events as they are unfolding, and that could not be more clear. He's describing the circumstances. We believe it's clearly admissible under the court's prior ruling of a spontaneous statement.
Final thoughts?
I'll stand with my argument, Judge.
All right, lines. This is on page 7 of the transcript of the 911 call that's been provided to me. The question is, beginning on line 2, we need the police before the mother, her mother, and line 3, the little girl gets back from the park. I don't want them, line 4, to find this. I've already ruled it's not an excited utterance. This in no way, shape, or form is the declarant, hearsay declarant, describing or explaining an event that that person has perceived while they're perceiving it or immediately thereafter. That portion is out.
Thank you, Your Honor. The next portion, Your Honor, is on the very next page, page 8, and there's 2 on this page. I'll start on line 9 through 11. And it is the caller speaking, Mr. Sant. So in case he isn't, he can't get up. I am also armed if he does come over and try to harm her, just so everybody knows. It's the same argument, Judge, that this is not a present sense impression of what's going on. This is he's become aware of what's happening and formed an opinion and has decided that to arm himself, or maybe he was armed already, and is letting the 911 caller or taker know that and just reflecting on what's going on. And so we would ask that it be stricken.
Mr. Taylor.
So according to 9803, Your Honor, spontaneous statement is defined as describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. So here is the neighbor, Mr. Sant, who's a former combat veteran, who has just encountered Miss Benefield, hysterical, saying that her husband attacked her and she shot him. And as this is taking place, he does not know what condition Mr. Benefield is in and whether or not Mr. Benefield may be coming through the door momentarily. He's explaining the circumstances as he perceives them as they are happening. And we believe that this is clearly included in the spontaneity of his statement.
State?
The state would just say that those are not events that are happening at that moment. They're events that she reported what happened when she came over. He's now had time to think about it. He's several minutes into this phone call, and he's decided that he's armed, so if he comes over and tries to harm her.
All right, I'm going to allow it as a present sense impression. The hearsay declarant is describing or explaining an event while he is perceiving the event or immediately thereafter. That's all he's doing is explaining that he's armed, explaining the situation and why he's doing that. So that's in.
Thank you, Judge. The next would be page 8, lines 20. It begins on 24 and goes to 25. And it actually continues on to page 9. The operator says, on line 1 of 9. And then in line 2, Mr. Sant says, explaining it isn't what people think it is when it happens. And it's the same argument from the state judge that this is him telling the 911 operator what he is doing, but I don't know that it's relevant, and it's not a event that he's not recounting. He's saying, I'm comforting her. And the second part is really an opinion as to page 9, explaining it isn't what people think it is when it happens. That's an opinion that he's formed, and he's telling her what he thinks. So it has to be stricken.
Oh, I'm so sorry.
I just that it be stricken, Judge.
Mr. Taylor.
So, as the court knows, there's no exception in the spontaneous statement provision for an opinion. It just requires that it be a statement made while the speaker is perceiving an event or immediately thereafter. So here is Mr. Sant, the neighbor, who has just had Miss Benefield come to his home and explain that her husband attacked her and she shot him. And now he is trying to calm her down, and he's explaining this as it is unfolding to the 9/11 operator. And part of his effort to try to explain and calm Miss Benefield down while he's speaking is to say that is to say shooting someone, is not what people think it is. This is him spontaneously expressing that. His perception.
Nothing else, Judge.
All right, in looking at these two, I'll allow at the bottom of page 8, line 24 going into 25 as a statement of then existing mental, emotional, or physical condition. I'll allow that. However, at the beginning, top of page 9, line 2, going into line 3, explaining it isn't what people think it is when it happens. I don't see in any way how that's describing or explaining an event while the person is perceiving it or immediately thereafter. He did not witness or perceive the actual event, so that's out.
Thank you, Your Honor. The next one would be the next page, page 10, as I've numbered the transcript. It begins on line 21, which is Miss Benefield is an inaudible, but the main portion is 22 through 25, which is, honey, and the state's asking this be stricken. Some of them were asking to be stricken, some were asking to be in, so that's why I'm just clarifying. Honey, I got to stay on 911. Let's look out this way. Make sure you don't see her. They're probably still at the park. If we see them, we'll go out and stop them. Okay. Would that be all right, ma'am? Which is a question. And then the operator says, yeah. And this again, we're asking it to be stricken as it is. The state feels it is not a present sense impression, Judge.
Mr. Taylor.
Yeah, I think it's very clear that as this is happening, he's explaining it. There's no time for him to methodically think about this. He's reacting to the circumstances as they are unfolding. And this is his articulation of that.
State.
I don't have anything else, Judge.
This is, obviously I've already ruled it's not excited utterance. This is not a statement for the declarant making it to the operator describing or explaining an event while perceiving or immediately thereafter. This is the declarant speaking directly to, presumably, Miss Benefield.
Actually,
I'm sorry.
I was going to say he's saying this on the phone.
I understand. No, I'm not going to allow 22, 23, these are lines, 24, 25. They're not excited utterances. It's not a present sense impression. I can't think of any other exception that would allow it. Over to page 11.
Judge, before you move on, I just didn't hear you correctly. 22 through 20, all four lines, 23 to 22.
Yes.
Thank you, sir.
Going on to page 11, line 1.
That's really just to make it make sense if we're...
I understand, and that's my ruling, that I'm looking back on 10, page 10, it'll have, what ma'am, I'm just getting everything on the screen okay, caller. are okay. Yeah, and then line 2 comes out for continuity's sake, and then on line 3, the operator's yeah, and then it'll just pick right back up with the operator. You should have a deputy pulling up here soon. Do you see him?
Thank you, sir.
So line 2 is out.
Yes, line 2 is out, and then on line 3, yeah.
1 and 2.
Judge, the operator, okay. I was going to take it out just for continuity because the last thing she would have said
Yes,
before that
line
was okay.
1 and line 2.
Thank you, sir.
And then the yeah on line 3. I'm sorry, I thought I was being clear, but so on page 10, it's lines 22 to 25 are out. On page 11, line 1, line 2 are out, and yeah on line 3 is out.
Thank you, sir. What I believe is the final one, Judge, is on page 14. It starts at line 13 and is through the end of the page, which is line 25. The state is seeking to include this in the call. The defense has asked that it be stricken. This is the operator says, what is the female's phone number? The caller says, I don't know. I'd have to ask her if she could tell. I don't know it offhand. Operator says, can I get her phone for? Can you get her on the phone for 1 second? I can ask her myself if you need. The caller says, can you talk to her for a minute? Speaking to Ms. Benefield. We have unknown because there's a dispute as to who responds, I can't. The state feels it's Ms. Benefield, but we're going to leave it unknown. The caller says, no. The operator says, I just need her phone. Tell her I just need your phone number. I'm not asking her any questions. Caller, all she needs is your phone number. Ms. Benefield, it's an audible, and then the caller says 941, and the state's asking that come in. It's relevant as to her. They're going through something immediately, and he's asking her questions back and forth. Certainly, we think that her one statement, I can't, comes in as not hearsay because it's the defendant's statement. But he's asking her for her phone number, and the operator is telling him, and he's trying to do it at the same time, and the state would ask that it be admitted.
Yes, sir.
So I would expect the court's rulings to be consistent. And in light of the court's parsing of the transcript thus far, this is a conversation between Mr. Sant and the 9/11 operator that has nothing to do with the event. I don't see how this is possibly relevant or admissible under a spontaneous statement. It is certainly not his statement explaining an event or condition as he's perceiving it. And just like before, this is no different. It should not come in.
It's relevant because it's an interaction with Ms. Benefield, and at one point the state would argue that she responds to these questions. But also, half of this call is between the 911 operator and Mr. Sant. The state's objections were to things the state felt were opinions, not presence and impressions. This is him interacting with this defendant about her phone number and the 911 caller asking the same, and we just asked that it be admitted.
All right, thank you both very much. So page 14, beginning at line 13 and going through 25, I've already found it's not an excited utterance. I do not find that this is a spontaneous statement where the hearsay declarant is describing or explaining an event after or while perceiving it or immediately thereafter. This is an interaction where questions are being asked of the caller and then recited to the state believes it's Ms. Benefield. It says unknown. I don't find that there's any exceptions that would allow this portion in. If I just didn't argue it state, but with the fact that it's unknown, I get that you want to argue it's Ms. Benefield, and it very well may be, but I'm not seeing any basis for this to be admitted. This is obviously conditional, though. That may become relevant or admissible in the future, but right now, lines 13 through 25 are out.
Judge, and we could address, if you don't want to address it now, but we could play the portion of the call. And the state believes it's...
I've listened to it.
Oh, okay. I'm sorry.
Remember, I did not read the transcript. I listened to the audio so I could hear for myself.
Yes, sir. I'm sorry. I didn't realize that. The state's argument is Mr. Sant asked Ms. Benefield, and the response is, I can't. So
I understand.
Yeah.
Your Honor, if I may, just for purposes of trial, I assume that a clean, if you will, copy of the transcript reflecting the court's ruling will be created. But if the state seeks to introduce the tape, they're going to have to redact the portions that the court has ruled are not admissible. If the defense seeks to introduce the tape, we will do so according to the court's ruling. But obviously, the court's ruling has no teeth if the court rules some of the things are inadmissible and the state plays the tape and it includes those portions.
I'm so confused right now.
Okay.
Do you mean you think? Hold on, let me make sure. Are you saying that I just took the time to make all these rulings on the disputed redactions, and you think the state would try and introduce an audio recording that had in it the things I just excluded?
No. I want to just make sure, though, that that's the case, that they are going, if they choose to play the tape rather than the defense, that they will redact it accordingly.
If they didn't, I would lose my mind.
All right, Judge.
I've made the rulings. If the defense is going to proffer this evidence, you've got my rulings. If the state is going to offer it, you've got my rulings. If you're going to provide a transcript that you want the jury, that obviously does not go into evidence, but you want to facilitate the jury's listening and understanding, then you need to agree on the transcript, and whoever's offering would need to have extra copies for the jury.
Yes, sir.
And
very good.
And I would just caution either side to follow my rulings.
Of course, Judge. I mean, we redact these regularly. Thank you.
There it is. Okay, how about the state's motion in limine to request proffer of expert testimony about domestic violence and abuse and memorandum of law, which was filed July 1st of 2024. And before I get too far into that, we've got one of the issues. No, maybe that wasn't this one. Maybe it was another one. Okay, you have that one handy?
Yes, sir.
State?
Yes.
All right.
To me, Judge.
Yes, ma'am.
To me. Okay. And first, Judge, I would like to say that the timing of the filing of this had a lot to do with when the state had access to this expert and when the state had access to depose this expert. Originally, the defense and I had agreed that the state would wait until this expert completed his investigation before I could do a deposition, because obviously it wouldn't be worth it to take a deposition in the middle of his examination. So the state filed this very shortly after the first opportunity we had to depose the expert. And I would stand by my motion and just highlight a few areas. The ultimate issue, because I recognize right now, Judge, we haven't heard all the evidence, the court hasn't heard the evidence, so you don't know how it's all going to come out. I have doubts about whether this particular expert, based on what the defense has represented, he will testify to. I have doubts about whether this would be admissible. So that's why I request that this testimony be proffered at the appropriate time, which may be after all the other evidence is in, so the court can make this determination if this evidence is admissible. And as outlined in my motion, I believe it's very clear that there is a specific exception carved out for battered spouse syndrome. The Oquendo case and some of the other case law makes it very clear that things like PTSD and those types of things are not allowed in a self-defense case. There is an exception carved out specifically for battered spouse syndrome, and as outlined in my motion, the court goes into why. And most of what the court states about battered wife syndrome and why it's allowed is that there are things that the jury would not maybe understand that is associated with battered wife syndrome, like why the person would remain at the home, why the person would recant, why the person would constantly blame themselves and not the abuser, why they would have kept in a situation that might have been dangerous. This is the stated reason that battered wife syndrome may be admissible in these types of situations. That being said, the defense has repeatedly said that this is not going to be a battered spouse syndrome defense, that this expert is going to testify about domestic violence and domestic abuse. So it's the state's first contention that there is no exception carved out specifically for that. And even if this information were to come in, it would be governed by 9702, which is the experts, when an expert is allowed to provide information to a jury. And an expert is only allowed when the facts are so obscure that they can only be made clear through an expert interpreting them. The basic information about domestic violence, that is not so obscure that you need an expert to testify about. And the things that are obscure are the things that were listed in the battered spouse syndrome. So it is the state's belief that we need to be very careful about what this expert is allowed to say, and the only way for the court to make that determination is to hear the testimony ahead of time before it gets in front of the jury. And the case law is clear about, we hesitate to let an expert talk in front of a jury because the jury may substitute the expert's analysis for their own independent analysis unnecessarily where not needed. So the state would ask for this to be proffered ahead of time.
All right. Did you depose? Give me a name. Who's this human being?
Bruce Ferris. Bruce Ferris.
Like Ferris wheel?
Yes.
Bruce Ferris.
And I deposed him, Your Honor. He confirmed that he is not talking about
when?
battered spouse.
What day?
June 26th.
Okay.
And he confirmed he was not going to speak about battered spouse syndrome. He confirmed that he did interview the defendant for several hours. However, he stated that that interview did not play into his decision making and any of his opinions. And he also said that the state, not knowing what he was going to testify to, asked him if he had any opinions. It is the state's contention that any opinions that he had are inadmissible because one of his opinions is that the defendant is a victim of domestic violence, which I don't think that's something he can testify to in a trial. So it is unknown to the state what this expert would testify to. His opinion is that there was domestic violence and that this defendant was a victim of domestic violence, and I don't know how that would be admissible.
All right, I have not seen a transcript, so I'm relying on you. Is that when you presumably asked him, tell me all opinions you've been asked to render in this matter? And his answer was?
Ms. Benefield is a victim of domestic violence, and Doug Benefield is a perpetrator of domestic violence.
What did he testify that he based his opinions on? If his interview of several hours did not play into his decision-making at all, what did he testify was the basis for his opinion?
The discovery that he received from the defense, and mostly the defense's stand your ground motion.
Okay. All right. Anything else?
No.
Mr. Taylor.
So I'm reluctant to go back into this only because the court's already addressed this, and under the tests announced in Hickson that the Florida Supreme Court set out, Your Honor ruled the testimony admissible. So now I'm back, and I feel like for a second bite by the state to convince the court otherwise. I will tell the court, so Your Honor understands, Bruce Ferris is a former deputy sheriff who specialized in domestic violence. He created the domestic violence unit for the sheriff's office in Gainesville, Florida. He ran it as a supervisor. He then, because of his fascination with domestic violence, went back to school, became a licensed mental health counselor, and specializes in, of course, what else? Domestic violence. The deposition that Ms. O'Donnell took went to Mr. Ferris's credentials. He was very clear to explain to Ms. O'Donnell at that deposition that no evaluation was ever conducted of Ms. Benefield, that the only questions that he had asked of Ms. Benefield was, given his background before and his status as a coveted expert witness, before he signed on to something, he wanted to make sure of its legitimacy. He then proceeded to explain and answer all of her questions. We filed, as the court knows, notice of intent to rely upon battered spouse defense, and we attached, as the rule requires, all of the information that was relevant to that. I footnoted that because battered spouse syndrome, as announced by the state Supreme Court, is the umbrella. Underneath battered spouse is abusive behavior. The distinction, subtle as it might be, Judge White, is that most of the time in battered spouse syndrome cases precisely, the victim still resides with the perpetrator, and they are subjected to repeated physical beatings. Domestic violence and abuse is a little broader, but it is the same factors, and it carries the same psychological issues for the victim. Here's what our Supreme Court said about that. If the court will indulge me briefly, and I'm reading, Your Honor, so that the court knows, from the Oquendo decision, which is at 357 Southern 3rd, 214. It's a 2023 decision by the 2nd District Court of Appeals. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind to the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. Thus, unlike PTSD evidence, battered spouse syndrome evidence does not tend to show that a sufferer's perceptions were impaired or altered by the condition. Rather, it goes to show that while the defendant's perception of the danger was reasonable, her choice to remain in the dangerous situation, despite the risk she would have to exert force to protect herself, was also reasonable. There is a difference in purpose between the expert testimony offered in battered spouse syndrome cases and in cases such as this one before us, post-traumatic stress disorder. In a battered spouse syndrome case, the factor upon which the expert testimony could be offered was secondary to the defense asserted, offered not to show through the expert testimony that the mental and physical mistreatment of the defendant affected the mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because she suffered from the syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. In this case, Oquendo sought to introduce PTSD evidence to show why he might have mistaken as dangerous what others who do not suffer from PTSD would perceive to be less dangerous or not dangerous at all. By contrast, a defendant introducing battered spouse syndrome evidence would be supporting her theory that she was not mistaken in her perception of danger, arguing that she had made rational choices in response to a reasonable assessment of the riskiness of her situation. That is to say, that she had done what a reasonably cautious and prudent person might have done under the circumstances, despite the appearance of danger having been so real that she believed it could only be avoided through the use of force. See Florida Standard Jury Instruction 3.6F. As such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. Resolving this evidentiary question does not require a value judgment that one condition or another is more or less worthy of excusing the use of force by an affected individual. Rather, it is the language chosen by the legislature to describe the justification of self-defense that renders battered spouse syndrome relevant and PTSD irrelevant. Now, Mr. Ferris explained, for the exact reasons that the state seeks to distinguish, that just as battered spouse syndrome, these events are cumulative. They have a lasting impression. And so when and if confronted at a later date, all of these prior incidents have a direct bearing on how the individual perceives and reacts to the circumstances. Clearly, we've met the test announced by the Florida Supreme Court in Hickson, where the expert is going to then respond to a series of hypothetical questions that I will ask based upon what is in evidence at the time we call the expert. The court's made that very clear thus far. There is absolutely no reason why he should not be allowed to testify, and there is also absolutely no basis upon which the state is entitled to a proffer in addition to a full deposition that they were able to take.
Thank you, sir. Ma'am.
Judge, first I would like to address, defense said that you've already ruled that this testimony is admissible, and I am completely confused by that. So if I need to be corrected, someone needs to let me know, but it's not my understanding that this was ruled on previous. Mr. Taylor just spoke for 5 minutes about battered spouse syndrome, but he said we're not doing battered spouse syndrome, so that's why I'm confused. All of what he just talked about was battered spouse syndrome. This expert in a deposition said he had never testified about battered spouse syndrome. He did not intend to testify about battered spouse syndrome in this particular case. He gave those two opinions that I told you, and he said that he did speak to Ms. Benefield on the phone. I think he called it a veracity gauge or something before he would take the case, but then that he had two separate meetings with her that were each about 2 hours apiece. So he has interviewed her, and in Hickson, it says that a person can testify about these things in one of two ways. One way, if the expert has evaluated the client and then testifies that she has or he has battered spouse syndrome and testifies directly about that, or someone that has not evaluated the defendant can testify about hypotheticals based on facts that are in evidence. So the state would argue that by interviewing this defendant for 4 hours, in addition to the phone call, being provided all of this discovery material, being provided the stand your ground motion, this expert has evaluated Ms. Benefield. The state has not had the opportunity to evaluate her. So for the expert to testify about hypothetical issues based on facts and evidence, I think it is possible that the expert could do that, but I think it's very touchy that this person may say something that would reference an interview or the discovery that he's read or the stand your ground motion that he's read. I believe that it would be very difficult for this expert to only answer hypothetical questions. I, as an addition to that, do not agree that this expert should be allowed to be asked hypothetical questions because it's not battered spouse syndrome. From all I know, he's going to be asked about domestic violence, and I'm not sure what about that needs an expert to explain to the jury. And clearly his opinions cannot come in under any of these cases. It does not say that someone can say so-and-so is an abuser and so-and-so is a victim unless they're going to say they suffer from battered spouse syndrome, which is not what this expert is going to do. So the state would just ask that Your Honor agree to a proffer ahead of time so we can keep this expert contained. Thank you.
Do you have anything else you want to put on the record?
Yeah, here's my response, Your Honor. I'm going to need a drink of water before.
Of course. Here. Of course.
Thank you, Your Honor.
Sure. Absolutely. State, you got your own drinks?
Yes.
Thank you.
So the court's going to have to indulge me, but I want to read something from the state Supreme Court in Kathleen Weiland versus State of Florida. This is at 732 Southern 2nd, 1044, and it's a 1999 decision reversing the second DCA. And the issue that was involved was a conviction for second-degree murder, and whether or not there should be a duty to retreat in the home. And this was the Supreme Court addressing that. And one of the reasons, the overriding reason that they gave for refusing to do that was what they style as implications for victims of domestic violence. And this is what the Supreme Court had to say. And again, I appreciate the court's indulgence for the record.
More continuing coverage is on the way. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.